cannot make a meeting on Friday. So, I mean, I don't mind delaying this. I quite frankly, I would like to discuss this in open session. I don't know why the settlement isn't discussed. It seems like everything else has been in the open, unless there's something significant that's going to damage the city.
Yeah.
We're referring to going into executive session?
Yes.
Regarding the Mr. Bayliss.
Could I would
Councilor Mercer.
move not to go into executive session and to discuss this issue on the council floor. To go into executive session, to me, seems to imply or give one the impression that wrongdoing occurred, and Mr. Bayliss did nothing morally wrong, in my opinion, and therefore I would support not going into executive session unless, of course, there was a confidentiality clause by both parties, and no one should be discussing it in open session. So I think if we could do it out in the public, I would just rather do it right here, if it's possible.
Well, if the solicitor could comment.
As far as the city, what we could do, particularly if it's going to be delayed, we could certainly contact the other side, and if there's no objection to having an open discussion.
I already talked to Mr. Bayliss. He has no problem with talking about it in public.
All right, so that we can take the matter up. Okay. I mean, we'll have to confirm that with his attorney.
I'm telling the truth.
No, I know you are,
Sure.
but I think the attorneys should talk to the attorneys on this.
And I want to know, if we ultimately have a confidentiality clause and we have to go technically into executive session, why would Mr. Bayliss not be allowed to go into executive session? I always thought that if you went into executive session, the city of Lowell versus, let's say, John Smith, and we were going to talk about John Smith, that he had every right to be there, as it was years ago when we went into executive session with the department head, and he had a right to be there. How come Mr. Bayliss doesn't have the right to be there?
I'll let the city solicitor.
Oh, doesn't. The purpose of the executive session was not to discuss, say, the charges or reputation character that falls into a certain category, but rather just to answer any questions in the event that the council had any, or to explain in more detail than otherwise has been done thus far the parameters of the settlement agreement.
Just to get, I believe Councilor Kennedy made a motion that we delay action on going into executive session.
There was no second.
There was no second,
Yes.
but that's what is there someone willing to second that motion?
Council Mercier made another motion.
Well, I made a motion, since he didn't get a second,
Okay.
to do it in open session.
I'll second that.
All right, we have a motion to do it in open session, seconded by Mr. Kennedy, but we need confirmation from Mr. Bayliss.
The city would be happy to have a discussion in open session and release the documents in open session, but we would not be in a position to do that without conferring with opposing counsel for Mr. Bayliss.
Mr. Chairman,
Councilor Kennedy.
my understanding of the requirements for the executive session would be that Mr. Bayliss would have had to been notified and would have had to been given 48 hours notice. And so if he wasn't given that notice, we probably shouldn't be meeting even in an executive session, never mind open session. But if we're just meeting to discuss the what happened and what the city's exposure is, why do we have to notify opposing counsel? The matter's already squared away and signed. Why does opposing counsel have to be notified at all? It's all we're looking for is what was our exposure on this matter? How did it end up for us? Can you explain that?
Sure. Let me try to address those issues. The first issue with respect to notifying Mr. Bayliss, again, that would be if we were going in for a certain purpose, namely to discuss character, reputation, hear charges against someone, things of that nature. That's not the intent at all. As far as the having an open session. We would not be given the parameters of the litigation and the agreements that have followed. We would not be in a position to be able to do that at present, but perhaps we would be in a position after I have an opportunity to speak to Mr. Bayless's attorney.
I don't understand why that is. My understanding was that the matter was settled and that everybody had signed off on that. So if that's the case, why is it necessary to speak to Mr. Bayless or his attorneys?
Well, for example, and Councilor Mercier had referenced as one issue, in the event of confidentiality agreements, the city would want to be in a position in certain cases to be able to address any questions that the council might have and to be able to be in a position to fully apprise the council of what goes on in a particular case. Not all cases, obviously, rise to the level where there's council involvement. This one, obviously, I think is something that we wanted to make sure that when the matter was addressed, that there was a mechanism so that in the event that the council did have questions or wanted to discuss it or have a better sense as to what actually went on, that we would be able to do that, but that would occur pursuant to documents in an executive session form. It's not at all unusual that parties will, upon resolving matters, request confidentiality agreements and things of that nature.
Is a confidentiality agreement part of the settlement with Mr. Bayless?
I would rather, if you don't mind, I just don't want to state something until I have an opportunity to talk to his attorney. Let me think of how to...
Madam Solicitor, that's a pretty simple question. That's just a yes/no type.
Let me put it
There either
this,
is one or there isn't one.
Let me put it this way: I wouldn't want to, in the event that there was a confidentiality agreement or other substantive issues with respect to the agreement. If there's a confidentiality agreement, I don't want to state anything that was in the agreement until I've had an opportunity to talk to opposing counsel.
Right, but it would probably help this body in knowing how to proceed if we knew whether or not there was a confidentiality agreement or not. If there's a confidentiality agreement, then I can kind of see why maybe you'd want to discuss it. But if there isn't a confidentiality agreement right now, then I see no reason why there can't be a full discussion.
Right. If there wasn't one, I would agree. There would be no reason why we couldn't.
Okay, so is that like a roundabout way of answering the question?
I don't want to put either myself or the city in a position where I am explicitly revealing things that are in an agreement or not in an agreement. But again, what I have stated is that at this point, if there is a willingness on the other side, I would like to just reach out to the attorney and confirm that. And then we can proceed to have an open session on the parameters of this matter.
By acknowledging that there's an agreement, that is not revealing anything that's in the agreement whatsoever. But nobody on this city council put this on the agenda. It was put on by the administration, and so. Is there a confidentiality agreement? Right now, is there a confidentiality agreement in place, signed?
Right. The difficulty that I am having with the question is that in the event that there were, and it was part of an agreement, again, I don't want to be breaching an agreement, and there is apparently, if we're not going to be discussing it anyway this evening and delaying action, I will be able to, as I've indicated, reach out to the other side, find out what their position is on it. You will know whether it's an open session or an executive session, the contents of that settlement agreement, and hopefully you get a better sense as to some of my hesitation.
I guess what I'm having trouble understanding is why the very existence of a confidentiality agreement would be part of the confidentiality agreement. It would be as if the confidentiality agreement we both agree to this and no one can even admit that this document exists. I mean, how can you have that?
Well, again, if certain conditions are met within the contents of a document, that's how something like that.
Okay, I'm not going to push it anymore. It just is, it's odd to me.
Council Mercer.
Thank you, Mr. Chairman. The only concern that I have is if by chance there is a confidentiality agreement and it is determined that we can't discuss it in open session and we go in executive session, I would like to request that Mr. Bayliss be present. Even though we're not discussing his personality, I still want to know if he can attend. I'd like that to happen. That's my only concern.
Councilor Elliott.
I want to follow up on Councilor Kennedy's line of questioning because there's an agreement that's been reached. And there has to be stipulations and terms in that agreement, whether both parties agree to it being confidential or not. And so going back to the question, I mean, there is a motion on the floor that's been seconded that we have a discussion in the open. Now, it's, in my opinion, it's either there is a confidentiality and we cannot discuss it, or either there is or there isn't. I mean, this should be black and white. I don't think if there's no agreement, no disrespect to either to the other party, but we're representing the city and the agreement's done. I'd like to see the agreement. Actually, there's no reason why we shouldn't. I think we should have received a copy already. Considering why not? It's a public document. Unless that is part of it, that it's not a public document. So, Madam Sislis,
Right.
Yes or no? I mean,
Well, it's not. Again, I'm trying my best to explain it and not put the city or anybody else in any create a legal issue where there otherwise shouldn't be one. As far as the document being public, there is. It would be our position that the document is not public at this point. Councilor Mercy had indicated that she had heard from Mr. Bayliss. He has no objection. I'd like to follow up with his attorney. That was certainly not the way matters were left with respect to these agreements. I have a copy of it and was planning on sharing it with you in executive session. Part of the reason that we wouldn't just release the document in open session is that with the new open meeting laws, any document that would be given to the council in an open session would, by operation of law, become a public record. So if a document was not intended to be a public document and it was distributed to the council in open session, it would defeat that purpose. So that was the reason. But certainly, you have a right to see it. When we resolved this matter, we made sure that you did in fact were part of the process, so that you would have a right to see it, and that's where the matter rests.
What is the motion?
Mayor Murphy.
Thank you, Mr. Chair. I just want to sort of bring an end to this. This is, I think, a ridiculous academic exercise. The whole idea behind the confidentiality agreement as being a part of the settlement means that you can't reveal what's in the settlement. So that's what we're talking about here. I don't see any problem in delaying, discussing this while, allowing for the solicitor to have time to contact the counsel of the opposing party so that we can figure this all out. But having this discussion doesn't move us any closer to adjournment.
So we have a motion to hold the discussion in open session, but first we're going to check with the attorneys for Mr. Bayliss, and then we'll
Right.
proceed with it at that time.
That's fine.
Okay. Roll call.
Counsel Kennedy.
Yes.
Counsel Leahy.
Yes.
Counsel Lori.
Yes.
Counsel Martin.
Yes.
Counsel Madonza.
Yes.
Counsel Mercia.
Yes.
Mayor Murphy.
Yes.
Counsel Nuance.